section 64, proof of a document by primary evidence. In a case of Bal Bahadur Prasad versus Maharaja of Betia, 1887, it was held that where a document is not admissible for one reason or another, the court can decide at the final hearing as to whether it can be looked at for a collateral purposes. A written document can only be proved by the instrument itself. It is a general rule that if a person wants to get at the content of a written document, the proper way is to produce it if he can. Whether the content of any document are in a question either as a fact directly in a issue or a subalternate principal fact, the document is the proper evidence of its own content. But where a written instrument or a document of any description is not a fact in issue and is merely used as evidence to prove some fact, independent proof alienate is receivable. Thus, although receipt has been given for the payment of a money, proof of the fact of payment may be made by any person who witnessed it. So, although where the content of the marriage register are in issue, verbal or other evidence of those content is not receivable. The fact of marriage may be proved by the independent evidence of a person who was presented it. In the case of P.C. Purushottam versus S. Perumalai, AIR 1972, Supreme Court 608, it was held that a document is properly admitted. The content of that document are also admitted in evidence, though those contents may not be conclusive evidence. In a case of Subhash Maruti Avsare versus State of Maharashtra, 10 Supreme Court cases 631, it was held that mere filing of a document, its content do not state it proved. A certificate issued by an expert should be bought on the record by examining him. In the case of Amarjit Singh versus State of Delhi, held that where the report of the Central Forensic Science Laboratory expert was admitted in evidence without objection regarding its mode of proof, the same could not be objected to any later stage of the case or in appeal. The case of Prakash Cotton Mills versus M. Commissioner, AIR 1993, Bombay 387. It was held for the proving the content of the sale deed, the executant was not examined. Through the proof of his signature was offered. Though the proof of his signature was offered, the sale deed was not allowed to be admitted. In a case of Nandakishore Lalbhai Mehta versus New Era Fabrics Private Limited, 9 Supreme Court cases 755, it was held that where the witness merely identified the person who had allegedly signed the document but did not state that it was signed in his presence, it would not prove the content of the document. The case of Ramjawai versus Shakuntala Devi, AIR 1993, Delhi 330, it was held that no material which are not spoken to be by person who are competent to speak about them and are subjected to cross-examination can be relied upon. The executant of a document must be produced or his affidavit filed. In a case of U3 versus U Srinivas, it was held that mere admission of a document in evidence does not amount to its proof. Therefore, it is the obligation of the court to decide the question of admissibility of a document in secondary evidence before making the endorsement thereon. In a case of H. Siddiqui versus A. Ramalingam, 2011, 4 Supreme Court cases 240. It was held that it is the duty of the court to examine whether the documents produced in the court or the content thereof have any probative value. Now coming to section 65, cases in which secondary evidence relating to documents may be given. In a case of Krishna Kishori Chodrani, this section enumerates the 7 exception cases in which secondary evidence is admissible. Under it, secondary evidence may be given of the content of the document in civil as well as criminal proceeding. Secondary evidence of the content of the document cannot be admitted without the non-production of original being the first accounted for in such manner as to bring it within one or other of the cases provided for in the section. In a case of Abdul Razak versus Mayu, 1898, it was held that it is incumbent on the person who tenders secondary evidence is to show that it is admissible. The question of admissibility is ordinarily is for the court of the first instance. In a case of State Bank of India versus Ali Boy Mohammed, it was held that secondary evidence cannot be accepted unless sufficient reasons is given for the non-production of the original. In a case of Gurudil Kaur versus Registrar Cooperative Societies, AIR 2000, Punjab and Haryana, 82. It was held if the original document is inadmissible in consequences of not being registered or not being properly stamped, secondary evidence owing it to it being unstamped or unregistered, secondary evidence is inadmissible. Secondary evidence cannot be given to establish a fact, proof whereof by primary evidence is forbidden. Under no circumstances can secondary evidence be admitted as substitute for inadmissibility of primary evidence. Where permission was sought for producing secondary evidence of certain receipt on the ground that the original receipt were lost, the court said two things would have to be proved. There must be evidence of existence of original receipt and there must be evidence of their loss. In this case, there was no evidence on record even of the existing of the original receipt. The permission granted was held to be improper. In a case of H. Siddiq versus A. Ramalingam, 2011, 4 Supreme Court cases, 214. It was held that Section 65 of the 1872 Act provide for permitting the parties to adduce secondary evidence. However, such course is subject to the law's number of limitations. In a case where the original documents are not produced at any time, nor has any factual foundation been laid for giving secondary evidence, it is not permissible for the court to allow a party to adduce secondary evidence. Thus, secondary evidence relating to content of the document is inadmissible under the non-production of original is accounted for, or as to bring it within one or the other the cases provided it for this section. Secondary evidence must be authenticated by foundational evidence that the alleged copy is in fact true copy of the original. mere admission of the document in evidence does not amount to its proof. Therefore, the documentary evidence is required to be proved in accordance with the law. The court has an obligation to decide the question of admissibility of document in secondary evidence before making endorsement thereon. In this case, the main issue was that whether the power of attorney had been executed by the respondent in favor of defendant number 2, enabling him to alienate the suit property, and even if there was such power of attorney, whether the same had been proved in accordance with the law. The trial court decreed the suit, observing as the parties had deposed that the original power of attorney was not in their possession. The question of laying any further factual foundation could not arise. It was held by the Supreme Court that the trial court cannot proceed in such an unwarranted manner for the reason that the respondent had merely admitted his signature on the photocopy of the power of attorney and did not admit the content thereof, may not necessarily be lead to drawing an inference unless the content thereof have some probative value. It was further held that it is the duty of the court to examine whether the document produced in the court or the content thereof have any probative value. In a case of Sawake Kuka, 1951, it was held that where a party comes into the court registering his claim on a written title which the law requires to be registered, he cannot, when he failed to register and is in consequences unable to use his title deed, turn around and say that he could prove his title by secondary evidence. Therefore, oral evidence of the term of unregistered deed of mortgage required by the law to be registered is inadmissible. In a case of Ranjit Kumar versus Kamal Kumari, AIR 1982, Calcutta 493, it was held that secondary evidence was allowed where the defendant did not deny registered deed. In a case of Draupadi versus Mahagraha Bhagwant Singh, AIR 1995, Rajasthan 138, it was held that where the defendant petitioner sought to produce secondary evidence in respect of certain documents without showing his entitlement to produce it, the trial court committed no irregularity in rejecting his application. In a case of Ved Prakash Rastogi versus Nagar Palika Budan, AIR 2008, Allahabad 27, it was held that the plaintiff alleged that he was a Bhumidar, owner of the land, and in possession for more than 12 years. The court said that these were crucial facts which were essential to prove an ownership and possession. The certified could not be non-suited for non-compliance of Order 6, Rule 2 of a CPC.